All rise. The Court of Appeals, Division 1 is now in session.
Thank you. You may be seated. Good morning. I am Judge Ferruia. To my right is Judge Campbell. To my left is Judge McMurdy. And we are here for oral argument in our case number TX22-0002, Mesquite Power LLC versus ADOR. As you may know, we record and live stream these proceedings, so please give your name and introduce your client before you begin. You have a maximum of 20 minutes per side, although you do not have to use all of that time. We do require you to keep track of your own time. There are clocks in the podium for that purpose. Just remember that the time that's reflected in the podium is also inclusive of any time you would like to use for rebuttal, and it's your responsibility to suggest that. Please keep in mind we have read the briefing, studied the record, and discussed this case in conference. And with that, you may proceed.
Good morning, Nate. Thank you, Your Honor. Good morning, may it please the court. My name is Lisa Newville, and I represent the Arizona Department of Revenue and Maricopa County. I am going to try to reserve 5 minutes for rebuttal, but we'll see. The Arizona statutes require us to value Mesquite's property as it was actually used on the valuation date, which in this case was as a power plant that sold power both on the spot market and through a market rate bilateral contract. As Mesquite's appraiser, Mr. Simzik, stated in his report, it is fair to assume that a merchant power plant in Arizona will have a contract either with a utility or with some other third party. He then largely ignored both the revenues and the reduced risk of a power plant with a market rate contract in place, which is a legal error that this court should overrule. This court's analysis in this case should be similar to its approach in Eurofresh. In that case, the appraiser used a standard appraisal method, the cost approach, but used struggling properties for his obsolescence analysis. This court noted that a property with a contract in place to sell half of its production could not be massively obsolete. Similarly, the Mesquite power plant with a contract in place for guaranteed capacity payments and energy sales should not be valued as a struggling plant with no such contract in place. In Eurofresh, this court held that this legal error rendered the appraisal incompetent to overcome the presumption in favor of the county's value, and the same is true here. Similarly, our Supreme Court in the Cypress-Pima mining case found that even though the tax court found the taxpayer's appraisal more persuasive, it was so full of errors that even though it used a standard appraisal method, the capitalization of income approach, it was not competent evidence. And I could list 5 things that show that the appraisal in this case similarly was so full of errors to render it incompetent. First, the actual contract, the PPA, had capacity payments of $34 to $48 million, which is similar to S&P Global's projections using market data that said capacity payments should be in the range of $30 to $50 million. But the appraiser projected only $4 to $9.7 million, less than 80% of the market and the actual contract.
Was there testimony explaining why the appraiser took that position?
The appraiser claims, and again, this is very confusing because he went back and forth between saying, well, that you look at contracts, but you don't look at contracts. And the only evidence he seemed to rely on was ABB velocity, which was a one-page report that we don't even know what the question was, much less what the answer. But in the briefing, we raised this issue. How could it be so low? And Mesquite did not have an answer. Nor to the next part, which is because those capacity payments were so low, the appraisal projected EBITDA, basically net operating income, that was less than what Mesquite's owner, Southwest Generation, projected for just the uncontracted capacity of the plant. Again, no explanation for that. Third,
Weren't they backing out the PPA, though? Wasn't that the whole purpose? to
Well,
back
Your
out the
Honor,
PPA?
That's what I meant by it's not very clear from the appraisal. Is he backing out the entire PPA, valuing it as if it had no contract in place, or something else? And the appraiser went back and forth. Now, if you're going to back out the PPA's value, the value of the PPA is the marginal difference between a market rate contract and what the actual contract is. It's not all income from a contract. Almost all income from energy sales is a contract of some sort. And in this case, the contract was market rate. And I have two reasons to say that. First, the contract was completely renegotiated just months before the valuation date to increase the term, change the payments, and increase the amount of capacity reserve starting in 2021. And Mr. Simzik, again, their own appraisal, testified that the PPA represented the market for contracts in the eyes of Mesquite and its energy buyers as of September 15, 2017, just months before the January 1st, 2018 valuation date. And second, the contract amounts match very closely to S&P Global. S&P Global made projections based on just market data. It did not have the actual PPA or any information that's confidential. And Mesquite's appraiser, Mr. Simzik, relied on S&P Global for almost every single calculation in his cash flow analysis, except one, and that's the capacity payments. And that's because S&P projected capacity revenues for 2018 through 2023 at rates that would generate $30 to $50 million in capacity payments. That's similar to the contract, which had reservation fees, basically a capacity payment of 34 to 48 million. Compare those numbers to the 4 to 9.7 million that Mr. Simzik's using, and you'll see the contract was at market rates. Mr. Simzik was dramatically below contract rates.
So basically what you're saying is that Mr. Simzik took all of the electrical generation that was covered by the PPA and then zeroed it out. Is that about the size of it?
Yeah, he basically attributed all of the income that they make through the PPA to the value of the PPA, without actually valuing the PPA. And that's wrong as a matter of law. Now, in our opening brief, we cite a number of cases from other states that say you must consider intangibles when valuing the tangible personal property. And let's be clear, we're not saying you value the intangibles. We're not saying you're taxing the intangibles. These cases all were in states that do not tax intangibles. But you must consider them in valuing the tangible personal property, which is consistent with the Arizona statute, which provides, this is ARS section 42-14156. It is a cost formula, and it says when you value the tangible personal property under the cost formula by considering not only the invoice cost for that property, but also intangible costs, like installation and transportation. Thus, Arizona's own statute says you have to consider relevant intangibles when valuing the tangible personal property.
So if I'm understanding your argument then, your argument is, look, you have this thing, it's on the side, it's the PPA, and it is intangible personal property. But the presence of that PPA has certain effects, salutary or otherwise, on the valuation of the actual tangible property, the facility itself and everything that is included within it and is taxable by the business. Is that correct?
Yes, Your Honor.
Is that a fair statement?
Sorry, I don't mean to talk over you. Sometimes the whole is worth more than the sum of the parts. So together, there is a value to this plant of having a plant with a contract in place. And that's what the courts all say, is you must consider that. And if you're going to take out an above market contract, you look at that value and you take it out. But we're entitled to tax the benefit of having the two things together, which leads to the issue of reduced risk. The other reason Mesquite's income approach is incompetent is because of its cost of equity calculation. The appraiser used an 18.2% cost of equity, even though Southwest Generation thought it would only receive a 9.6% rate of return on its equity investment. So in other words, the cost of equity is twice what an actual market buyer thought they would get from this plant. And that's not true. In addition to get that 18.2% cost of equity, Mr. Simzik had a double count risk. First, he did a small company analysis that looked at a fake single asset plant and said if the only thing the LLC owned was the plant, no contract, it would have certain capitalized income, and that would create a 5.35 percentage point risk for small company. And then he added another 5 percentage points for the risk because he said a single asset is that much more risky than this fake single asset LLC. And there was no support for that. Remember, 5 percentage points may not sound like a lot, but that's the difference that both parties used in their appraisal for the market risk premium, which is the difference between a zero risk investment, a long-term government bond, and investing in the stock market in general. There is no support to say that a single asset would have that much more risk than the single asset LLC. There is no difference in diversification. There really is no difference in liquidity. This is the same additional risk with no evidence that this court rejected in Transwestern. Finally, in this case, the sales comparison approach was very important because it provides a vital check on the income approach. But again, Mesquite made both legal and factual errors with the approach that rendered it incompetent. Specifically, the appraiser's report listed 2 sales for the Gila River plant, which is also located in Maricopa County. In 2016, 1 block sold to SRP for $100 million. In October 2017, SRP announced that it agreed to buy 2 more blocks at that same plant for a total of $330 million in a sale that closed in early 2018, so right around the valuation date. The appraiser focused on the 2016 sale, but did not give any weight to the more relevant sale from late 2017.
Counsel, I'm trying to be respectful of the time you want to reserve. Can you please address to us what it is that the department is seeking here? I mean, in terms of relief, what is appropriate relief?
Your Honor, we are seeking a determination that the appraisal was incompetent and therefore did not overcome the presumption that the department's value of approximately $197 million was correct and should not have been overturned by the tax court. And remember, under this sales comparison approach, if Mesquite's appraiser had not taken out half the sale price for that 2017 sale on the grounds that it involved a PPA that was actually not part of the sale, that value would be $214 million, which is higher than the $197 million statutory value.
What would you say to the argument that these are all factual issues that you're talking about, and to the extent that the evidence was incompetent, that the matter should be remanded for more evidence?
Your Honor, it's not a question of more evidence. If the appraisal presented is not competent to, 1, support a finding that the department's value is excessive, and 2, establish a new value, then they have not overcome the presumption of correctness. So again, statutorily, the department's value is presumed correct, and it is the taxpayer who must overcome it. That's why we mentioned Eurofresh, where again, the court found it was incompetent, didn't remand it for a new trial. It remanded it to install the value of the county. Same thing in the Cypress Pima case, Cypress Pima mining case. Again, the court said the appraisal, which the court focused on these factual differences. It focused on the fact that the appraiser had used a certain line and trend line for costs, but not for its income. So the court found it was incompetent factually, but as a legal determination said that was enough to say that it was incompetent and therefore did not overcome the presumption of correctness.
So how does that work? We would just issue an order saying, I mean, in the opinion, we would simply say, exactly what you said, the presumption applies, they didn't overcome the presumption, so we remand it, but we direct the tax court to enter the statutory presumption.
Yes, Your Honor, that's exactly what was happened in Eurofresh. It was remanded with instructions to enter the county's original valuation.
Okay.
If there's no further questions, I'd like to reserve the rest of my time.
Thank you. Ms. Noyville. Mr. Mooney.
Good morning. May it please the court, for the record, my name is Paul Mooney. With me at council table is my partner, Bart Wilhoit. We represent Mesquite Power, LLC, the plaintiff and appellee in this case. You've just heard a number of things that are simply not true. This case involves a challenge to a tax court ruling based on 5 days of expert testimony from 4 different experts and 1 other witness who testified regarding the purchase of the subject property. The tax court, Judge Viola, issued a detailed 9-page ruling in which she outlined how she evaluated the evidence, and in particular, how she evaluated the credibility of the experts who testified for both sides. Her ruling is entitled to deference from this court under the applicable standards of appellate review, at least as it relates to any issues of fact that were decided. And the question of market value...
Aren't those mixed questions, though, Mr. Mooney?
There are some, Your Honor.
It seems like most of them are.
Respectfully, no, I disagree, because the issue of valuation, what a property is worth, is a factual issue. The Supreme Court in the Trico case notably said, values like beauty. It lies in the eye of the beholder. It's incapable of being calculated with mathematical precision and necessarily must be estimated. It is a fact issue, and I know this because I've tried numerous of these cases to juries. Under Arizona law, you're allowed to try a valuation appeal to a jury. I've done it 4 or 5 times in Arizona. And a jury renders a decision on the value, and they determine a number based on instructions as to the law that they're to follow. That number is essentially bulletproof on appeal, as long as it's supported by the evidence in the record.
But Mr. Mooney, isn't it the case that the rules of law that you give to the jury, don't those have impact on the fact that the jury can find?
Certainly, you give instructions that set forth what the law is. Let's talk about the law for just a second, because you're right, there is a legal side to any valuation appeal.
For example, Judge Viola in this case discounted the contract.
Discounted the contract?
Yes.
No, she simply found that the contract
Was an
non-taxable intangible.
Okay, and no one's disputing that it's different. But she discounted the fact that it had effect on the value of the property when the contract was part of the plant.
The property is not part of the plant, respectfully.
Okay.
The plant is an identified site-specific asset. It's a power plant. It's comprised of land, real property improvements, and tangible personal property that's used to generate electricity. The law says, in defining what is taxable here, that those 3 things, and it specifically uses the word tangible as an adjective to modify personal property, that is what is taxable. What is not taxable...
So you're saying that we cannot consider the contract as it relates to the value of the property?
The contract...
As a matter of law?
As a matter of law, I believe that is the correct answer.
And so if we disagree with you, Mr. Mooney, then we're not saying that there's a factual dispute, we're saying there's a legal dispute, and that the evaluation would be erroneous, right?
Respectfully, no. I don't believe that's correct.
Well, you just told me it was a legal issue on whether those we can consider. That's what you said.
The question of what is subject to taxation here is a threshold legal question. That is defined by statute, a statute that neither side disagrees with. That statute identifies 3 things that are taxable: land, real property improvements, and personal property. Specifically, only tangible personal property. And the statute then goes on to give examples of what that tangible personal property includes. In fact, it includes some things that you and I would probably think of as real property, like the foundations on which the equipment is mounted. But that's identified in the statute as tangible personal property. There's no question about what that property is. That property is subject to a tax lien. that property is liable for the tax if the tax is not paid.
Okay, you've come far afield to what we were talking about, and that is what deference we have to give to the tax court's determination. And you said we have to give her deference. And I said, okay, we don't on mixed questions. We don't on mixed questions because legally, if we say, or this court determines, that you have to consider the contract in determining the value, which would be the appraised value of the taxable property, that is a mixed question that we don't give deference to. It's a legal question that we would review de novo.
Respectfully, I disagree with you.
Okay, great.
And
Let's talk about...
The reason I disagree with you is this. The only legal issue that is implicated by Judge Viola's ruling in this case, or her decision, is the question as to whether or not income or revenues from the PPA can be considered or must be considered in valuing the taxable subject property. That's an issue as to which we spent a fair amount of time briefing cases from other jurisdictions which are not binding in Arizona and which aren't the law in Arizona and which are derived under statutes that are fundamentally different from Arizona law in terms of what is taxable. Those cases, none of them mitigate or none of them mandate a different result in this case. And the reason is because every one of those cases was what we call a unitary property tax case. Unitary cases are cases like pipelines and telecommunications companies and railroads and things that operate in multiple jurisdictions. And in those cases where the going concern value of the whole is what is being evaluated, it is absolutely a fact that in virtually every jurisdiction where you're dealing with a unitary property, those things are considered as part of the income to be capitalized, which might very well include a contract. However, we're not valuing a unitary property. We're valuing a site-specific asset located in Maricopa County on a piece of dirt that has equipment and real property improvements.
And sells electricity.
And sells electricity, absolutely.
And sells electricity to only Arizona?
It sells electricity only in the wholesale market because merchant power plants...
What does that wholesale market enclose?
The federal...
Is it only Arizona?
It goes through the federal grid, the point at Palo Verde, and where it goes from there is anybody's guess, because electrons are electrons. At the end of the day, you're selling electrons into that market point.
I understand, but the larger point here is what your market is.
The market is comprised of wholesale providers. It has to be companies that are authorized under the law, and that's a corporation commission issue in terms of the regulatory environment that they operate in.
Yeah, but the point I'm getting at is that when you sell electricity in wholesale markets, you're not selling only to Arizona markets, isn't that so?
You may or you may not be, and as a practical matter in this case, the evidence establishes that virtually all the power that's produced is sold, well, all the power that's produced is sold into what's called the Western Electric Coordinating Council pricing point at Palo Verde. It goes into the grid at Palo Verde. In fact, the Mesquite power plant is located physically adjacent to that power plant. And all of the power that it transmits goes into that facility. It's called the Hacienda switch yard.
But you're not arguing that the demand for that energy, that product that this plant is selling, only is confined to Arizona, are you?
There's a theoretical side to that question and there's a practical side.
Well, let's stay practical.
The practical side of it is electricity doesn't transmit over long distances very well, because it degrades over distance and time. So as a practical matter, that's why there are power facilities located all around the country close to where the demand is. As a theoretical construct, you could theoretically send electrons over a copper wire from Arizona to New York, but they would degrade so much that they would have not the same value as they have when they were generated. So as a practical matter, it is sold in Arizona. It's sold here, it's sold into the Hacienda switch yard, and where it goes from there is determined by APS, SRP, TEP, and anybody else who's authorized to provide electricity to consumers. It's not relevant to the question of whether it's taxable. We're not taxing electricity.
What is relevant to the question of taxable is what the value of this plant is.
It's value of the equipment that produces the power.
And under the income approach to valuation, what you can sell, or what the income stream, quite literally, for the plant is relevant to the question of valuation, is it not?
Respectfully, the answer is no to that question, and the reason is...
The income is not relevant in the income approach.
It's relevant in the income tax. It's not relevant to the property tax. The property tax is a tax imposed on property. The statute imposes a tax on property.
You know, we're talking about valuation, though, here. So are you saying that what you're telling me now, and because I want you to fix this, because
Okay.
if I'm misunderstanding this, what you're telling me is that the income that this plant generates is absolutely irrelevant to the question of how much this plant is valued at, what its value is at.
The way that question is phrased, I couldn't answer that no or yes, and the reason is this. The income that the plant produces, that income is generated by the plant, is a factor in determining the value. It was used by Mr. Simzik, who was the appraiser that was hired by the taxpayer to value this plant. And what he did is he said, I'm going to value this power plant the same way a buyer would acquire it. A buyer who acquired this power plant, and only the taxable power plant, would have an asset that has value. And I'm going to value that based on what that asset can produce in income. So in that sense, the income approach is relevant. But that approach values only the property, not income from a contract that has no relationship to the property. In fact, it's severable, it's separate. It was found by 2 tax court judges to be so. Judge Whitten first, after a 6-day trial, Judge Viola after a 5-day trial, hearing all the experts, including the same expert for the defendant in both cases. And both judges ruled correctly that what's taxable in Arizona does not include the value of what is essentially described as a call option. It's not a bilateral contract that has a fixed market price. It's a heat rate call option. It is exercisable by the seller, i.e. my client. And that obligation can be satisfied by going out into the market and buying power.
So Mr. Simzik testified something to the effect of that if this PPA, under his methodologies, if this PPA covered 100% of the generating capacity of Mesquite, then the property would be valueless.
No, he didn't testify anything of the kind.
I believe he did.
No, he testified what the
Okay,
power plant...
can you give me the chapter and verse where he did not? Where that...
I don't have the transcript committed to memory, but I mean, I'm happy to look it up for you and try to find it if we can.
That's okay.
But the answer to your question is, Mr. Simzik didn't value the PPA at all.
That's the point.
No, he didn't value the PPA because it's not part of the taxable property. He valued the power plant as a merchant plant that anybody could buy.
He valued the power plant as a merchant plant without any of its capacity available, or without a certain percentage of its capacity available to sell energy. Is that not so?
He valued it as a power plant that had all of its power available to be sold in the merchant market. What you just heard a minute ago is a misrepresentation of the record. What Mr. Simzik very clearly testified was, my assignment was to value the power plant. That's what I did. The power plant is a merchant plant. In fact, Judge Viola found that. We stipulated to that in the joint pretrial statement. A merchant power plant, by definition, is any power plant that can produce power and sell it into the wholesale market. This power plant qualifies for that without regard to the PPA. It has that ability and that right, whether it has a PPA or not. So Mr. Simzik said, my task is to value the tangible taxable property as defined by the Arizona statute. He read Judge Whitten's prior ruling. He read that before he started his assignment. He valued the property in that manner. He was not the appraiser in the prior case. We had an appraiser in that case who did the same thing. But in this case, he said, my task is to identify and value the taxable, tangible assets. He said, okay, I've got to value that as a merchant plant. I'm going to look at what a merchant plant in this market could sell power for and how much power it could sell. And I'm going to base my income approach on analyzing those numbers, which is exactly what he did.
Did that reflect the current use of this particular plant?
Absolutely, absolutely. Current use is an issue that came up for the first time in the reply brief. It's never been argued before. And I simply direct the court to the statute that defines current usage under Arizona law. 4211-001 subsection 4 says, quote, current usage means the use to which property is put at the time of valuation by the assessor or the department. The use to which property is put. The use to which this property is put is no different whether this property operates with a PPA or without a PPA. This property produces electricity. That electricity is sold into the grid. That's what the property is. There's no difference between a power plant with a PPA and a power plant without a PPA. The business might sell for considerably more or less if one has a PPA and the other one doesn't. The evidence supports, by the way, that finding, that indeed these are business transactions. And when you're valuing a business, it does trade for more money if it has a PPA than if it doesn't.
So it doesn't, hold on, if that's true, then you just said we're valuing the plant and the plant that you would do for a sell, if you were going to sell it. And you just said if it has a PPA, it's going to be worth more.
If you sell the PPA with it.
Okay.
The PPA doesn't have to be sold with it.
But currently, at the date of valuation, there was a PPA with this plant, and based on what you just said to me and to this court, was it would be worth more.
Respectfully, if you interpreted that from what I said, you misunderstood me.
Oh, then you better clear it up.
What I said, and the record in this case is absolutely clear. The PPA is separate, severable, and distinct from the plant. The power that's sold...
It may be severable, but it was in place at the time of the valuation, and that's what we look at.
No, it wasn't in place. It was sold with the power plant to the business that acquired it. We're not imposing an income tax here. We're not imposing a tax on the profitability of the business, Mesquite Power LLC. We're imposing a property tax on the value, the market value of those assets, what they would trade for, just those assets, between a willing buyer and a willing seller. There's no basis for the assumption that that power plant is not worth what it is intrinsically worth as a power plant. It is worth a set amount of money as a power plant. That's what it can trade for. If you are going to ask me what would a power plant with a PPA sell for versus what would a power plant without a PPA sell for, the answer is different. And in fact, I would submit, because of the value of a contract that guarantees $34 million a year in revenue, that plant has more value than the plant that's sold without it. In fact, Judge Viola made that express finding in her ruling, and she even said it is one of the reasons why Mr. Barreca, their expert, was not credible. She said, footnote 6 of her decision, page 8 of the ruling, including the income from the PPA in the analysis while claiming the PPA has no value, is inconsistent. That was what Mr. Barreca was doing. Moreover, by including income from the PPA, Mr. Barreca necessarily included the value of the PPA, an intangible asset, close parentheses, because without the PPA, there would be no income in the form of payments. Either way, Mr. Barreca's own report contains information as to the value of the PPA. He included it.
Well, isn't it true that we're talking about a power plant, and this power plant sells power, right?
It does.
Okay, so if you have one scenario where there's a PPA that gives you a captive market and you sell all of the power to that captive market on the one side, or you have another side where a power plant sells all of its power to another market, what's the difference?
The difference is the source of the revenue is from the rights granted by the contract.
No, but the question here is about what the income of the asset was, what it produced. That's the income approach. You capitalize income.
No. That is not the income approach. The income approach...
Excuse me?
It is not. When you value an apartment building, you value the income that building produces.
Right.
When you
So when you
value
value a power plant, you value the income the power plant produces.
Right, and that's exactly what Mr. Simzik did. He valued the power plant as a merchant plant based on what that merchant plant could produce in the market. We're getting into the weight of the evidence here at this point. Frankly, this is why I do disagree with the idea.
Well, I just disagree with you because legally, the influence of the contract is a legal question on how it affects, and that's a mixed question.
Then you disagree with both of the trial judges who heard 11 days
That's
of
okay.
testimony on this issue.
That's
And both
okay,
of them,
you
by
can.
the way, the first decision by Judge Whitten was not even appealed by the department. Not only did they not appeal it, they then settled the very next year based on Judge Whitten's decision. And Judge Viola significantly in her decision makes a note of that and says this is part of the reason why she didn't find Mr. Barreca's opinion credible. The court notes, this is page 7.
This is your wrap-up.
Yeah, the court notes that the tax court previously determined the value of the subject property to be $130 million for tax year 16 and $99.7 million for tax year 17. The parties settled the subsequent year and agreed to a value of $99.7 million for 18. Defendants now argue that the market value of the subject property is $432 million. The court does not find any evidence presented by defendants persuasive in supporting their position that the market value of the subject property increased by over $300 million between tax year 18 and tax year 19. Bear in mind, this is a decision they did not appeal.
Thank you, Mr. Mooney.
Thank you for your time.
Ms. Noida.
Thank you, Your Honor. I'd like to go through some of those points backwards, probably the most recent, or the last first. Again, the department's valuation is only $197 million, not $450 million. That value under the income approach must include all income that you would expect from the power plant. And Mr. Simzik stated that in Arizona, you would expect a merchant power plant to have a contract. If not this one, a market rate contract of some sort, which has to be taken into consideration. And in this case, as I pointed out, the PPA was market rate, so why not consider that? As a matter of fact, this court in Maricopa versus Viola, when considering the value of low-income housing properties, said you consider the contract for low-income housing projects.
But didn't that case diminish the value of the property?
Yes, Your Honor, but it works both ways. If you're going to consider contract income, actual contract income, not market income, you look at the contract income for that property. And even though those leases are intangibles, you still use that income. So in all cases, the fact that it's a contract, a lease, a sales contract, it doesn't matter. If it's expected income from the plant, you must consider it to get the fair value of the plant, because that's what buyers would do. And that's why the buyer in this case thought that this plant was worth $556 million. Let me also point out, I think there was a question about whether Mr. Simzik said if it's 100% contracted, there'd be no value, and that was in the sales comparison approach. And what he said is, yes, under his sales comparison approach, if it's 100% contracted, the plant itself has no value. All of the value is the contract. And he actually did that. When he looked at the Gila River plants, he said SRP bought 2 blocks. One it used, that was worth $165 million. The other one, it entered into a contract with TEP for TEP to use 100% of that plant. And he said that plant, block 2, had no value. That's how he got $165 million value for both blocks sold together. So again, it's sort of a misrepresentation of what's going on, a bit disingenuous when you're sitting there and saying, oh yes, all the value is the contract, when you would expect a power plant being put to its best use to have contracts in place. I also wanted to mention that electricity is sold to California. That's part of the record, that in the analysis that the buyer, Southwest Generation, was using, one of the facts they kept noting to their upline owners was that this was positioned to be able to sell electricity to California. As we all know, California's had some power issues, and this plant allowed that to happen. That could be part of why they thought that extra 110 megawatts could make money. They were projecting $12.5 million, I think, for EBITDA for just that uncontracted capacity versus the $6.5 million that inhibitor that Simsek used for the entire plant. So again, market is tight. They recognized in the appraisal, both appraisers said, Phoenix is growing. The Phoenix metropolitan area is going to experience a greater need for electricity. Even the PPA noted that in 2021, they had to increase their capacity being reserved by a significant amount. I think it went from 271 megawatts to 475 megawatts because there was an increasing need for contracts to reserve that capacity because a utility can't wait till it's 118 degrees out there and then find they don't have enough electricity available.
I have just a basic question I want to ask you. Everybody keeps talking about the PPA having value. What is the value of the PPA? There's not a dollar amount of value, is there?
No, Your Honor. The departments and the county's appraisers said he could not determine a value because we didn't have enough information. But they suggested two ways to do it. One would be if you could find a market rate PPA and do a comparison, you could look at that marginal difference. The problem is PPAs are generally confidential, so they're hard to compare. The other alternative is to look at what portion of the electricity under the Mesquite PPA is actually generated or is sold from power that's not generated at the plant. And if you knew that, you could figure out what is the savings or extra revenue you're getting that's not from the plant. But there isn't sufficient evidence in the record to do either of those things. That's why the department's appraisers said we couldn't value it, and Mesquite's appraisers did not value it either. They just did this mathematical assumption.
And Mr. Mooney refers to the other tax court giving it value, but my reading of Judge Witten's, he said, yeah, it's got value, but never determined a particular amount of value for the contract.
That's correct, Your Honor. And again, there's a problem between saying, well, the department's at $450 million and they're at $105 million. Actually, the department and the county are at $197 million. The fact that their appraiser thought the actual market value exceeded the statutory formula value is irrelevant. The question for this court is it less than $197 million, and exactly what that number is. I will point out that the last valuation, 97 million, whatever it was, just under 100 million, was in January 1, 2016. And the next one is January 1, 2018. And the court said it increased in value by just a little over $5 million. The Gila River plant in that same period, and I'm sorry, I'm a little over, I'll finish this thought, sold for $65 million more. And in this case, they added $27 million in new value. So it's hard to assume that it increased in value by only $5 million. Thank you, Your Honor.
Thank you, counsel. Thank you for your arguments. We will take this matter under advisement and issue our decision in due course, and the court is adjourned.